administration had determined were dangerous. And what he wanted to do was, he said, increase the vetting procedures. And that's what he said 3 minutes before he signed the first order, standing there next to the newly sworn in Secretary Mattis.
Sounds like you argue that our approach to these statements should be sort of an abuse of discretion review. If you could read the statements good or bad, we should defer to the good.
I think the value of the Mandel standard is that
you don't look.
Is that courts don't start engaging in this, but if you do, and for the reasons we've said in our briefs, we think as a matter of law you shouldn't. But if the court were taking them all into account, and here I mean not just the post-inauguration official capacity statements, but the campaign trail stuff, we would still say, look, the president clarified over time, and in the face of ambiguity about that, both respect for a coordinate branch and the presumption of regularity would require not reading them, I think as the district court did here, in the light most hostile and least favorable to the president.
We did, you're right. We did receive a number of briefs in this case, a number of amicus briefs. And Judge Hawkins' question reminded me of something that caught my eye in one of the briefs, which is the Korematsu, from the brief from the Korematsu Center. Would the Korematsu executive order pass muster under your test today?
No, Judge Pius.
Why not?
I want to be very...
Facially legitimate. That's all you say. You emphasize facially legitimate.
I want to be very clear about this. This case is not Korematsu, and if it were, I wouldn't be standing here and the United States would not be defending it. When counsel said below, and this is at page 116 of the supplemental excerpts of record, look, we'll concede that an order like this might well be constitutional in other contexts where you didn't have statements like this that they were attributing, an impermissible motive. I think right then you're not anywhere approaching Korematsu. I think I cannot imagine that any court would say that the justifications put forward.
How do you apply the facially legitimate standard to an executive order like that? I mean, there was no reference to Japanese in that executive order, and look what happened.
Judge Pius, I'm not familiar with all the ins and outs of that executive order. I haven't gone back and looked at it. I can't imagine that courts would say that it survived the Mandel standard. But the point is just, I think counsel here have implicitly recognized below that if some other president had done this without these statements, that this executive order would almost certainly be constitutional. And then what they're left with are the statements. And they're saying, all right, look, on its face, it's neutral. It doesn't operate on the basis of religion. But we think the president made clear over time why he was really doing it, and you should look behind it. I think that's a very different situation from Korematsu, and I don't think they've pointed to a single case, either under Mandel or even if you went under McCreary and Lukumi, that would say we have a law that isn't a religious gerrymander like Lukumi. It doesn't distinguish, it's not explicitly religious like McCreary, but we're still going to set it aside based on what we believe to have been the subjective motivations of the president or the advisors who adopted and crafted the policy. That's a really remarkable holding, Judge Baez.
Is a bad faith determination under Dinh the same thing as a purpose determination under Lemon?
I think it's a little different in the sense, Judge Hawkins, that it's one sentence of dicta in the Justice Kennedy concurrence, so I don't want to read too much into it. Because no court's ever applied it to actually find bad faith. But I think what he has in mind there is pretext. He cites the portion of Mandel where the court reserves the question of what would happen if the executive put forward no justification at all. So I think what he has in mind is when the consular officer either gives you no reason or gives you a reason that's obviously untrue on its face, a pretext sort of finding. I think that's a little different from purpose. And again, to say that the president and 3 members of his cabinet acted in bad faith pretextually by adopting an order and saying on the face of the order that it is for national security purposes when it's not, I think to go down that road, you would need the strongest and clearest showing of bad faith.
Solicitor General Wall, I would appreciate hearing a little more on the government's view on the statutory side of the case. And specifically, what I have in mind is that there's in 1182, there's a need to find that entry would be detrimental to the United States. And so I have a question whether there's an adequate finding of detrimentality to justify keeping everybody from a particular company out of the country, from a particular country out of the country. And then I also have a question on making it a national origin ban, because that seems to conflict with the 1985 statute, although that was limited to immigrant visas. But if you could touch on those issues, I'd appreciate it.
Sure. So, Judge Gould, on the first question, and the Fourth Circuit had a number of questions about this too, the President in sections 1D and E and F of the order makes clear that what he's concerned about, he's really two things. One, the ties between terrorist groups and these 6 countries that were listed by Congress in the previous administration, and the concern that the governments of those countries and the deteriorating conditions in places like Iran and Syria may mean we're not getting reliable information. And so what the President found was, he said, look, I find that it would be detrimental to let in their nationals for a brief period of 90 days while I ascertain whether the vetting procedures that we have in place for these countries are actually adequate. So he wasn't saying, I find that it would be detrimental because they're all dangerous or they all are potential terrorists or anything like that. He was saying, in the face of uncertainty about whether we're getting good information from their governments so that we can screen them out in the visa process, I'm going to put a temporary hold subject to the visa waiver. And I think under a Mandel rational basis review, but frankly under any legal standard, I think the President's detrimentality determination there would easily survive. The second half of your question gets back a little bit to what Judge Hawkins and I were talking about. 1182 is entry. 1152A is issuance of immigrant visas. The State Department has always reconciled those by saying that when the President suspends a group, even if in part on the basis of nationality, that the reason for the denial under 1152 is not the nationality, it's that you're subject to a valid suspension. So the State Department has in practice always reconciled them so that we're not giving travel documents to people who would arrive and then we would keep them from entering. But again, if the court disagrees with us on that, I think at most it would be the basis for an injunction that said for the 30% of aliens or so subject to this order who want immigrant visas, we'd be required to give them the visas, even though when they arrived, we wouldn't have to allow them to enter the country because of the 1182F suspension. I think as the district judge in the Maryland case recognized that that wouldn't be a sensible result. I think the State Department's reading of these statutes is the far more sensible one, but no matter what reading you take, unless you say that the President is disabled, every president, permanently, from making any nationality-based distinctions under 1182F, Reagan with the Cubans or Carter with the Iranians, unless you take that road, I don't think there's any way to read the statutes that could provide the basis for the injunction we have here. And if I could just reserve the remainder of my time. Thank you.
Thank you. Okay, Counsel Cottrell.
Thank you, Judge Gould, and may it please the court. The government would like to pretend that this court's decision in Washington versus Trump never happened, but it did, and the government can't shut its eyes to it. There's a simple test. Ask yourself, if you accept any of the arguments you just heard, would it have altered Washington versus Trump? If the answer is yes, that settles it. So when the government claims that Mandel applies, even though Washington said it didn't, when the government claims you can't look beyond the face of the order, even though Washington said you could, when it claims the injunction harms national security, even though Washington said it didn't, and when it says the state doesn't have standing, all of these were things raised and decided by Washington versus Trump. If I could.
Did the Washington panel decide the application of Mandel on the merits, or to simply say that courts have jurisdiction to review such things?
It resolved the question of whether the Mandel standard of bona fides.
You think our panel is bound by that?
I do, and if I could read to you the language from Washington versus Trump. This is found at page 1162. The government cites Mandel for the proposition that, quote, when the executive exercises immigration authority on the basis of a facially legitimate and bona fide reason, the courts will not look behind that. The government omits portions of the quoted language to imply that this standard governs judicial review of all executive exercises of immigration authority. In fact, the Mandel standard applies only to executive branch officials to issue or deny an individual visa. The present case, by contrast, is not about that application of a specifically enumerated congressional policy. That's this case, Judge
You read
Hawkins.
a little bit more into the case than I did.
I'm just reading to you.
Well, I do. Well, I understand that, but they didn't really decide those questions. They decided that case based on due process grounds.
Oh, they certainly decided on
Clear.
due process. I'm not saying that that they reached the establishment clause in found a violation. I am saying, however, for purposes of Mandel, the government came forward before this court in Washington versus Trump and said the standard that governs all of this case is facially neutral and bona fide. This court recited that standard back to them and said it doesn't apply. That is a square holding of this court. If I could, I'd like to start with Judge Hawkins' question about the Establishment Clause. You asked my friend, Mr. Wall, has the president ever disavowed all of these statements? And I thought his answer was surprising because he couldn't actually point to you any disavowal. He just cited en masse amicus briefs because the truth is there is no such statement. We give you chapter and verse, the things the president has said. The district court gave them to you as well. They're both pre and post inauguration. There's not just one. Starting in December 2015, when he called for a, quote, total and complete shutdown of Muslims entering the United States. Then a few months later, quote, I think Islam hates us. We can't allow people coming into this country who have this hate of the United States. Then a few months later, my opponent, quote, would admit tens of thousands of refugees from the Mideast would try to take over our children and convince them how wonderful Islam is.
Mr. Katyal, let me, those statements are profound. I mean, I'm familiar with them, we've read them and everything else. But it is a little bit concerning, though, that those statements take place during the midst of a highly contentious campaign.
Absolutely, and we wouldn't be...
So, don't you need to look at it from that perspective as well?
Well, we wouldn't be standing here if it was just campaign statements on its own, but as the district court found, the president rekindled those statements through his actions as president in two different respects. First, when he issued the first executive order, he read the title of the executive order, looked up at the camera and said, we all know what that means. That's at SCR 148. And that is, if it was clear from the title what it meant, he wouldn't have had to say it. It's a reference to something else. And indeed, when he issued both executive orders, he left on his website that very statement about the complete and total shutdown of Muslims, a statement that just happened to disappear moments before the Fourth Circuit argument last week. So I think the question is, what would an objective observer view these statements as? And as the district court found, it would view them as an establishment of a disfavored religion of Islam. We're not saying that we're not in favor of psychoanalysis or trying to get into the president's head. You don't, Your Honor, need to be Sigmund Freud in order to affirm the district court. You just simply must ask, as the Supreme Court has told you, what would an objective observer think with these sorts of statements? And these statements, by the way, just one last point, do continue. Even last month, the Doe brief, which was filed before you, says even last month, the president said it's a lot easier for Muslims to immigrate than Christian refugees from the Middle East. And, quote, he's going to be helping the Christians big league. So this is a repeated pattern of the president. Indeed, 2 months ago, to this day, when the district court struck down the injunction in this case, this is at SER 84, the president said, quote, moments ago, I learned that a district judge in Hawaii, part of the much overturned Ninth Circuit, just blocked our executive order. This is a watered-down version of the first one. And let me tell you something. I think we ought to go back to the first one and go all the way, which is what I wanted to do.
Does that mean that all those statements, post-election statements, even the one you just read, does that mean that the president is forever barred from issuing an executive order along these lines? What does he have to do to issue an executive order that, in your view, might pass constitutional muster?
Not at all. So I think there's two paths that the president could take in order to pass constitutional muster. One is the way that our founders thought, Article 1, Section 8, which is Congress, which is in the driver's seat with respect to immigration, passes a statute. And as Justice Alito said, when Congress passes a statute, it's much less likely to discriminate. It's 535 people versus one, which is why his Mandel point is so problematic. That's number one. Second thing they could do is the president could do all the kinds of things, or some of the kinds of things, remove the things that the district court found led an objective observer to say that this discriminates. So one example would be what Judge Hawkins said about disavowing formally, all of this stuff before. But that's not it. I mean, he could do a lot of things. He could do, for example, and I'm not trying to micromanage the president, but he could say, like President Bush did right after September 11th, quote, the face of terror is not the true faith of Islam. That's not what Islam is about. Islam is peace. Instead, we get, quote, Islam hates us. I think Islam hates us. I think he could point to changed circumstances from December 2015 when Congress debated the exact same evidence that the president relies on in his executive order and say, you know, we actually need more than just denying people entry without a visa, which is what Congress required. You need to do more than that. You know, it could eliminate the text, which refers to honor killings. You know, there's a bunch of different things that could be done. And our fundamental point to you is that presidents, presidents don't run into Establishment Clause problems, and the reason for that is that this is a very limited, in a really unusual case in which you have these public statements by the president. Indeed, if you affirm the district court, there's not a thing that any president has done in our lifetime that would be unconstitutional.